Hi, everyone. This module is to talk a little bit about student discipline and student search and seizure. All right, these are sort of two separate areas, but they're frequently related because frequently you're searching and seizing with the intention of disciplining a student. Okay, so we'll talk about them both. Let's start with student discipline. All right, so student discipline is obviously the broader topic here. And in schools, we engage in student discipline all the time, like very frequently. And so this area of law comes into play very, very, very often. All right. And to understand student discipline, at the root of it, we have to understand how the 14th Amendment grants kids some rights in their education. All right. So the 14th Amendment says that no state shall deprive any person of life, liberty, or property without due process of the law. That's what the 14th Amendment says. So, of course, education is an entity that's run by the state, and here the state is depriving kids of an education, so we need to kick in due process of law, education being defined as part of their property right because it has some value. All right, fine. So, due process of law, we have to give that to kids every single time that we're going to take away the educational benefits, the educational right. All right, so what does that mean? So, due process at its core means two things. It means notice of the charges, like what did I do wrong that's causing you, state official, teacher, to take away my education, and let me have a chance to explain myself. All right, so notice and an opportunity to be heard are the core of student discipline rights. Fine, that's the due process requirement. Okay, so this due process requirement, though, is a bit of a sliding scale so that when you're talking about things that are relatively minor, like just sitting out in the hallway, that's taking away the education of the kid because the kid's not in the classroom learning with their peers. So taking away that education does click in the 14th Amendment, but the due process required for that very minimal removal of that right is very low. All right. So you just ask the kid, hey, do you know what you did wrong? Let the kids say what they might have done wrong. And then tell them, well, I saw you passing notes in class, so I need you to go sit in the hallway for the next 5 minutes. All right? Super small, but every single time going through that little process protects you as a teacher under the 14th Amendment from that kid ever coming back and saying, hey, you all took away my right to an education without giving me my due process rights. It's rare, but it could happen, so just making this a habit is a good thing to do. Now we have, of course, in schools, things can scale up, suspensions, expulsions. All right, so in terms of the WHO engages in the process of suspensions, usually you're talking about school leaders making those choices about who is going to get suspended in a given for a given incident. When it rises to a level of expulsions, then hey, the school board gets involved. Suspensions, of course, have a limit on them. They can be sort of up to 10 days. If it's a special needs student, it can only be 10 days throughout the entire school year. But at any given instance for a regular education student, you can suspend up to 10 days. If any suspension lasts over 10 days, that's an expulsion. So no matter how hard, how bad the kid has behaved in your class as a teacher, you're never going to get a suspension more than 10 days because doing so really, that's an expulsion and that's a whole different kind of step. All right, so you just need to understand that as teachers, the principals are trying to work within these rules. All right, so an expulsions, of course, can be a year. It really depends on what the infraction is, on how long the expulsion happens. All right, the due process for suspensions requires some paperwork going home. There does need to be notice and an opportunity to be heard, a little bit of a hearing. That can, of course, just happen in the principal's office. Parents can be called in to talk about it. That's sort of all that's sort of required at the suspension phase. At the expulsion phase, though, if you have a kid in your class that you intend to expel, what happens at the school board level is that there's sort of a mini trial that happens in front of the school board. And that mini trial is to determine issues of evidence and issues of fact, like who told whom to what. All those kinds of questions come out in that little mini trial in front of the school board. You, as a teacher, of course, will be asked to come and testify in front of the school board about what happened and why. Okay, so anytime a kid gets expelled in your classroom, well, you can expect to have to go to the school board meeting when that kid is expelled and testify, tell the story as you saw it. Other issues in school discipline. So we used to do a lot of zero tolerance 1 year's expulsions around weapons. There's been a bit of a pullback on that in the last few years, a little bit more flexibility. And sorry for my kids playing and screaming in the background. Nowadays, also, there is some provision for assault and battery of teachers. There's some way to prosecute kids that engage in assault and battery of teachers. Kentucky does not prohibit corporal punishment. It is legal in Kentucky. However, many school districts choose to ban corporal punishment. Fayette County is one, for instance, that has banned corporal punishment. And grade reductions are not permitted, okay, as a result of school discipline. Now, the student might miss work, and that missed work, that can be part of the grade, but punishing a student by reducing their grade is not permitted. That is not. So Johnny does something wrong in class, it doesn't rise to the level of suspension or expulsion, but you just want to take away 10 points off of Johnny's grade just as sort of punishment for what Johnny behaved for his behavior. That is not legal. All right, let's turn our attention then to search in this module. So search is, of course, related to discipline because you're constantly searching or seizing things, and you're conducting those searches and seizures in a way that leads to potential discipline if you find what you're looking for. Now, when police want to search someone, that requires probable cause. So you all are adults now, and so when you're out and you're, over at, let's pick Tin Roof on a Friday night, and the police come and they say, hey, I'd like to search your purse, or I'd like to search your wallet. Like, you can absolutely refuse and say, I would like to see, number one, probable cause and potentially a warrant. So there's very high search bars for adults. That's not the case for kids. For kids, we only have the reasonable suspicion standard. That reasonable suspicion standard is made up of two parts, all right? A search must be justified at its inception. There must be real, individualized evidence that this kid has the thing that you're searching for. And it must be reasonable in scope, all right? So if you got evidence that this kid, that whatever you're searching for, the drugs or whatever, is in the kid's purse or backpack, then only search the purse or backpack and don't search their pockets and don't search their shoes or don't search their lockers. So you have to really limit your search only to where you think that particular item is. If you do those two things, though, a search is justified at its inception and it's reasonable in scope, then you are protected as a teacher and as a school from any potential backlash later. This comes up a lot in cases of drugs because kids will get caught busted with drugs at school. The school officials, the teachers, the principals don't do the search correctly. All of the result of that search, then, all that evidence is considered spoiled, and that case gets thrown out. So the quality of your searches is frequently questioned, particularly when it comes to issues of drugs. Just keep that in mind. Now, as the search gets closer to the person, the expectation of privacy goes up and up and up. Obviously, our expectation of privacy in our locker is way lower than our expectation of privacy in our pockets or on our person, of course, right? So the amount of evidence needed and the rationale needed for that search goes up the closer it gets to the body. All right, so the justified at its inception part of the reasonable suspicion standard that justification goes up as it gets closer and closer to the body. Nowadays, things like strip searches are pretty much entirely prohibited. There has to be threat of immediate danger, as in you think a kid has a gun on them. And even in those instances, I would ask you to get the school administration involved, and then I tell school administrators that they should be getting their school resource officers involved in those instances, of course. A few Supreme Court cases of note: New Jersey versus TLO. This was the first case in 1985 that really outlined the search and seizure rights of kids and created the reasonable suspicion standard. Prior to that, just like all these other areas of law, kids had no search and seizure rights under the Fourth Amendment prior to 1985 in New Jersey versus TLO. Extracurriculars have been brought up several times. So Vernonia and Earls were both around extracurricular activities. Because the courts consider extracurricular activities a privilege and not a right, the privilege comes with the ability for the school district to search more. All right. So, and if you as a student don't want to be searched, then you can not engage in the extracurricular activity. This, of course, has really come up with drug testing. All right. And so there is some ability to randomly test in extracurricular activities, random drug testing. This, of course, applies to sports, but the chess team, the yearbook team, all of those could also be randomly drug tested. All right, that's a little bit on student discipline and student search and seizure. Hope you found it interesting.